Well, let's figure out, I guess after this, we'll figure out whatever days and times that you're available.
Thank you. Please be seated. Good morning. First is Brad Johnson. Mr. Johnson. Good morning, sir.
Good morning, Your Honor. How are you this morning?
Doing well. How are you?
Doing well, sir. Your Honor, I have Brian Dean Howard, case number 22CF2185. Michelle Sand was the prosecutor on this case, but it was set for pre-trial conference earlier. We had moved to continue it, and it's been continued to September the 11th, but we still had today's jury trial review in the July 18th notice to appear that came out. We are rescheduling depositions. One of the primary witnesses for FDLE was on a joint task force going out of the country for a period of time. So we had it set, but we had to reschedule it, and we're working on that.
Any objections from the state?
No, Your Honor, it was the state's understanding this was already continued to the next cycle.
Continue until September 11th.
Yes, Your Honor. But the notice to appear came out after that. Court had already continued it and said to be here today, so I figured I'd be here just in case. So,
Thank you, Mr. Johnson.
thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, sir. Have a great day.
You do the same, sir.
Good morning, Your Honor. Keith Kilpatrick representing Mr. Jose Cabrera. He is in custody. He's before the court, case number 21CF1101.
Watching the first round of the British Open.
My bad. Sorry about that, Judge.
Tour de France going on right now, too?
Judge, my understanding is that they can hear us on Zoom.
Are we on Zoom?
Ms. Jacob, you can't hear us, Ms. Jacob? No.
It's not up on here. And Mr. Cabrera is present before the court, case 20. And before the court, case numbers 21CF1101 and 21CF1365. I have a plea to tender to the court, if I may approach, Your Honor.
I've got a score sheet attached, Mr. Honor.
Thank you, sir.
Judge, would you like me to announce the plea?
No, sir, just give me a moment, let me make sure that I understand.
Yes, sir.
Bless you. Good. Mr. Cooper, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. You put your hand down. So, Mr. Cabrera, are you currently under the influence of any drugs, alcohol, or medication?
Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, Your Honor.
How far did you go in school?
The 9th grade?
Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with this representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, Your Honor.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, Your Honor.
Do you believe it's in your best interest to enter the plea?
No, Your Honor. Yes, Your Honor. Sorry.
Well, but understand, don't say it just because your attorney said that. You know, knowing everything that you know, taking the advice of counsel, knowing the upside and the downside, do you find that it's in your best interest to enter the plea?
Yes, Your Honor.
Has anyone forced, threatened, or coerced you into entering the plea?
No, Your Honor.
Has anyone promised you anything other than what's in the written plea agreement?
No, Your Honor.
Okay, the last question I have for you is kind of the opposite of that. Has Mr. Kilpatrick or anyone else told you, Mr. Cabrera, if you do not enter a plea today, you're going to be sentenced to 10 years or some definite sentence?
No, Your Honor.
Mr. Cabrera, I do find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel. Are you satisfied with Mr. Kilpatrick's representation of you?
Yes, Your Honor.
When you state you are satisfied, I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty in count 1 of 21 CF 1101. Count is dismissed. Count 2, you're adjudicated guilty to the lesser included offense of felony battery with great bodily harm. You're sentenced to 22.2 months with the Department of Corrections with credit for all time served, and that's going to be concurrent with the other sentences that I imposed today. That's followed by 3 years of probation. And that's concurrent to count 1 in 21 CF 1365. Count 3, adjudicated guilty, 5 years probation, consecutive to count 2. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. Also have the $276.43 cost of transportation due to the Okaloosa County Sheriff's Office. You will have to submit to sexual offender counseling and treatment. You'll have no unsupervised conduct with any minors and no contact with either the victim or the victim's family. In 21 CF 1365, adjudicated guilty, felony battery with great bodily harm, 22.2 months with the Department of Corrections with credit for all time served, followed by 3 years of probation, and that's concurrent with count 2 in case number 21 CF 1101. Again, all the standard fines and court costs are imposed. Sex offender counseling and treatment, you need to submit to that. Have no unsupervised conduct with any minors and no contact with either the victim or their families. Just to make overly sure, all of the sentences are to run concurrently, run at the same time, other than the probation It's to run consecutively, and your incarcerated sentence is with credit for time served on both cases and all counts. Yes, ma'am.
And Judge, for the record, in 21 CF 1365, the victim is YR, date of birth 6/15/2007. And in 21 CF 1101, the victim is JC, date of birth 1/23/08. And in accordance with Marcy's law, 21 CF 1101, we have notified the guardians and they do not wish to be present for the plea this morning, and we have made reasonable efforts to contact the victim in 21 CF 1365.
Thank you, ma'am. Mr. Cabrera, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. You cannot afford an attorney to represent you for that appeal. One may be appointed for you. Do you understand your appellate?
Yes, Your Honor.
Thank you, sir.
Thank you, Your Honor. I'm also covering for Jeff Toney, case number 22 CF 1751, State versus Miguel Santa Maria. Mr. Toney asked me this morning if I could get a continuance for him. He said that some of the key witnesses did not show up or were not available for depositions. He needs to reset those.
Any objection from the state?
There's no objection, Judge. This is one of the cases where we hadn't heard from Mr. Tony, so it was set off to try and contact him. At the docket day / pre-trial date, there was no one present, but there were some witnesses that did not appear for deposition, so we need to get those reset.
That's what I need to do. Thank you. It's continued until September 11th at 9.
Thank you very much, Your Honor. Thank you.
Thank you, Mr. Kirkpatrick. Mr. Cotton.
Morning, Your Honor.
Good morning, sir.
I have one case on your docket this morning. That's going to be Tammy Lee Ware. Ms. Ware is present, and we've reached a plea agreement in that. If I may approach.
Yes, sir.
Tammy.
Thank you, sir.
Yes.
Good morning, Ms. Ware.
Good morning.
Ms. Ware, did you, not that you pretend to first, do you swear to tell the truth? You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Did you put your hand up? Ms. Ware, did you read the plea agreement?
Yes, I did.
Do you understand?
Yes.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea
I
agreement?
did.
I swear I do accept your plea. Adjudication is withheld. You're sentenced to 12 months probation. You need to pay the $615 in court costs, perform 24 hours of community service work, and you may buy that out. You need to show proof of a valid driver's license or eligibility during that time period. There's also $40 per month cost of supervision. Thank you, ma'am. Good luck to you.
Thank you.
Your Honor, Mr. Gates asked me to advise the court. He's in Walton County this morning, that he's on his way. Just want to let the court know if he's not here when the court calls him.
Okay. Thank you, sir.
Thank you, Judge. That's all I have for the court.
Thanks, Mr. President.
Yes, sir.
Mr. McCaviges. I don't see Mr. McCaviges.
Your Honor, I believe he's talking with his,
Okay. Mr. Weinstein. Good morning, sir.
Good morning, Judge.
Your Honor, I'm here representing Jonathan Lonzit, 23 CF 130.
Is Mr. Weinstein, is he in the back? He's not an inmate, right? Here he is.
Your Honor, this is going to be a misdemeanor plea to reduce charge of improper exhibition of firearms with no contest. I have a signed plea agreement. May I present it?
Please, yes, sir. Good morning, sir. If you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand up. Did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you sign it?
Yes, sir.
Do you have any questions for the court or your attorney or the state regarding the plea?
No, sir, not about the plea.
Okay. Anything else that we can help you with?
Since it's not going to be a felony.
Correct. It'll be a misdemeanor.
Yeah, it was my dad's grandpa's gun. I was just wondering what do I got to do to get it back.
Okay. You'll have to petition to get that back. Mr. Weinstock can talk to you about that.
Okay. Yeah, that was the only question I had.
Okay, good. So I do accept your plea. Adjudication is withheld. You're sentenced to 3 months county probation. Auto termination, automatically if you've completed all the requirements. You need to pay the $270 in court costs, perform 24 hours of community service work. As Mr. Weinstock states, you reserve the right to appeal all motions and judgments. There's also, in county court, is it going to be county court probation through felony probation, or are you going through?
Felony, misdemeanor probation to the JCS.
Okay. And so JCS, I believe it's $50 per month. Thank you, sir.
Yes, sir.
Your Honor, that's all I have.
The statute number for the lesser included offense.
Lesser included offense, do you
I'll
have the
get it.
statute number?
I'll get it. It's
This needs to be charged up.
Oh, it does? Okay.
790.1.
Thank you, sir.
Thank you.
Mr. Noakes? Good morning, sir.
Judge, I've got Kevin McNamara. Judge, he's Judge, the state and I have agreed to set this for 9/11. We've got plea negotiations that are ongoing. If we're able to get it settled before 9/11, we'll schedule it for an early plea.
Okay. So what are you going to do between now and then?
He's going to
Your Honor,
contact the victim.
Your Honor, the state is in the new law, because we were pretty close to getting to a resolution in the 22 case. In the new law, I just need to speak with the victim in regards to any restitution. As of this moment, the defendant does score out to prison, but we're trying to figure out the amount of restitution and if that would be something the victim would be willing to agree to not going for incarceration in lieu of going for a probation with restitution. So I just need to speak with the victim, and then we'll.
Good. Mr. McNamara, I'll see you back here no later than September 11th.
Yes, sir.
If the state offers you something that you want to accept before that date, Mr. Noakes can set a hearing before then.
Perfect.
Thank you very much.
Judge, and then William Morgan. Judge, we've also agreed to put this on for the 11th. We had hoped we could have the PTI paperwork together, but we're not able to do so. We're going to get it together and get it filed well before the 11th, and it should just drop off the docket.
That's correct, Your Honor. I just wanted to let you know there were a couple of situations that we had the case on Monday and it's set for Thursday with the intention of us getting PTIs. I was able to get a couple of them sent out, but I've really been trying to work out the trial cases. But this is an agreed upon PTI, and I'll make sure to get that so it falls off the docket.
Good, thank you. So, Mr. Morgan, it sounds like that I won't see you on September 11th. If the PTI paperwork goes through, then you don't have to be here. If it doesn't go through, I'll see you on September 11th at 9.
Yes, sir.
Thank you, sir.
Thank you.
Judge, the next case I have is Javier Sabio. Judge, the state, on Mr. Sabio's, he's got 2 cases on the docket, but the one that we're particularly focused on this go-around is 22 CF 664. The state had filed an amended information, and we formally, for the record, we're waiving the reading of that, and we've already entered a not guilty plea. And then we've got some scheduling issues that we're working on. You want to say anything about the scheduling?
Sure, yeah, so I've confirmed that all my witnesses are ready to go to provide testimony either on the Friday of the first week or the Friday of the 3rd week. It's my understanding that Mr. Noakes would prefer to actually have testimony on the last week of the trial cycle. I'm fine with that. I would suggest that we take a jury the Thursday prior and actually go to trial on that Friday.
Take a jury on the 10th.
So, yeah, so specifically I'm talking about picking a jury, sorry, I'm pulling up the calendar. So picking a jury August 10th and begin trial August 11th.
Judge, those days are clear for me, so that's perfect.
Okay. And how many will you need on the Venari? Mr. Sabio, the Venari is the jury pool. How many do you pick the jury from?
How many is the normal pick, Judge?
22, I think, is the start, but we've certainly been doing significantly above that in civil cases.
Yeah, I don't necessarily know that 22 alone will be enough because we've got a lot of stuff.
I was thinking somewhere around 30 or 40.
Yeah, there's a lot of peripheral stuff going on with other folks as well as this case. So whatever 30 to 40 you think, Judge?
You want to divide the baby 35?
I'm fine with 35 as well, Your Honor.
So 35 on the Venari. So we'll pick the jury on August 10th, start on August 11th.
Judge, I do need to make one brief record before we conclude this case today.
Yes, sir.
So there was a filing by Mr. Sabio on May 12th, 2023 that's titled as a correspondence from defendant to his attorney, Marty Noakes, that reflects some misunderstanding related to the potential exposure that he faces under the 1020 life law, commonly referred to as 1020 life, but section 775.087. What concerns me is that in that filing, Mr. Sabio is very focused on the 25-year minimum mandatory exposure rather than the alternative exposures to 20 or 10 years. So I just need to make this record today to respond to that filing and also to preclude the success of any post-conviction motion down the line in which Mr. Sabio claims that he did not enter a plea in this case to the state's offer of 15 years based upon his misunderstanding of his exposure under 775.087. So namely what I need to state is that even if the jury does not find that Mr. Sabio's weapon fired the bullet which struck either of the victims, causing great bodily harm in this case, it can still find him guilty of aggravated batteries under a principal theory, and also find that he discharged a firearm in the course of his commission of those offenses. If it finds such, then this court is required to sentence Mr. Sabio to 20 years. There are 2 counts of aggravated battery with 2 victims, so if that were the case, this court would have the discretion to stack those sentences and sentence Mr. Sabio to 40 years, which is not to mention his exposure under count 3 to the aggravated assault. So now that I have made that record, I will once again state to Mr. Sabio that he has been offered 15 years to plead in that case, and of course, if he doesn't, the state remains ready for trial.
Mr. Sabio, did you understand everything that the state just stated?
Yes, sir.
Do you have any questions for the state or your attorney or the court?
No, sir.
Do you still wish to go to trial?
Yes, sir.
And I'll see you no later than August 10th. Okay?
Okay.
Thank you, sir.
Not the other case, just to check.
Yes, sir.
Judge, the next case I have is Sean Sanders. May I approach Sean?
Yes, sir. Thank you. Yes, sir. Well, Mr. Sanders.
Hello, Judge.
Judge.
Go ahead, Mr.
In Mr. Sanders' case, 21 CF 572, we're entering a no contest plea as charged. The understanding is he'd be adjudicated guilty and be sentenced to the Department of Corrections for 18 months. Judge, he would get no credit for time served. The state would agree not to pursue anything to appears, and it's agreed upon that this is an agreed upon downward departure, $615 court cost and $150 court-appointed legal assistance fee.
And are the misdemeanor counts time served?
Time served, yeah.
Mr. Sanders, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Sanders, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
College.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Absolutely.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Sanders, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Has anyone forced, threatened, or coerced you?
No, sir.
Has anyone promised you anything other than what's in the written plea agreement?
No, sir.
Kind of the opposite of that is, has Mr. Noakes or anyone else told you, Mr. Sanders, if you fail to enter this plea today, you shall be sentenced to 5 years in prison or any other definite sentence?
No, sir.
Mr. Sanders, I do accept your plea. Are you satisfied with Mr. Noakes' representation of you?
Yes, sir.
I find that you are alert and intelligent, that your plea is fully and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied.
Yes,
I
sir.
find that there is a factual basis for acceptance of the plea. You're adjudicated guilty, and you're sentenced to 18 months. Do you understand that if I accept this plea, that you're waiving your right to any credit for prior time served?
Is that credit, that the time that I did, what did that go to towards?
You wouldn't get any credit for it at all. It wouldn't reduce the 18 months.
Okay.
You'd still get credit going forward, like gain time and those things, but as far as credit for what's happened up until today, you wouldn't get credit for it.
So that went towards my misdemeanor at that time that I did, time served?
Time served, yes, sir.
That makes sense, yes, sir.
Mr. Sanders, you're sentenced to 18 months with the Department of Corrections with no credit for time served. The misdemeanors, you're sentenced to time served.
Okay.
The state will not pursue any failure to appear, and this is an agreed upon downward departure. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. You understand your appellate rights.
Yes, sir.
Thank you, sir. Good luck to you.
Appreciate it, Mr. Morrison.
Yes, sir. Thank you.
Thank you.
Over here, sir.
So that's all I've got.
Thanks, Mr. Mayor. Does the state have a score sheet?
Not for me, Judge. That's actually all his fault. Thank
Thanks,
you.
Mr. Evans. Yeah, get us one. Mr. Flowers?
Good morning.
Good morning, sir.
Judge, the first matter, I don't know how it appears on your document, Mitchell McGahee, and he is here. We anticipated, Your Honor, and did in fact receive from the state, maybe day before yesterday, pretrial intervention agreement that we're going to be entering into. My client is here, he's been very cooperative. If you could give us a date certain by which we could sign and turn that into the court.
Why don't we just continue it until September 11th?
That'll be fine, Your Honor, if that's fine.
Mr. McGahee, that means that if you're accepted into the pretrial intervention, then you don't have to be here that day. Stay in touch with Mr. Flowers, they'll let you know. If for some reason something goes sideways and it's not accepted, then I'll see you on September 11th at 9.
Thank you, Your Honor.
Thank you, Your Honor.
Judge, the next matter, Marcus Lane. Yeah. Your Honor, in meeting, we anticipated a deferred prosecution agreement, still anticipate that. Your Honor, if that were placed for 9/11, I believe it will dispose of itself by the filing of the DPA or dismissal.
And that's correct, Your Honor. We have come to an agreement. It's just one of those ones that I need to get it to defense counsel.
Okay, it's continued until September 11th.
Your Josh Lopez, and I believe that's likewise same prosecutor.
Yes, same thing, Your Honor.
With the same, we have an agreement, we're going to have it, sign it, it'll be filed. If 9/11 is fine with the court, it'll dispose of itself prior to that date.
It is?
Well, not finally, but Elijah Sutton, and if you recall, well, I know that you've read your notes because I know you do that. We had been waiting for a report from Dr. McDonald on this. We received it last night after hours, but I was provided information. We do have it. You know, we're asking for 9/11 because we just got it. In fact, I haven't had an opportunity to read it yet. I don't believe the state knew that we just got it, but that's where we are. You know. So we're asking for 9/11.
Yes, sir. It's continued until 9/11.
Your Honor, Mr. Patel, Jay Patel has a case. The last name, if I'm not mistaken, is Tran, T-R-A-N. Mr. Tran is incarcerated in the state of Mississippi, serving a sentence.
He should be, I'm sorry, he should be appearing by Zoom. I'm not sure if he's on.
Okay, I don't know that answer.
Anybody, Mr. Tran?
Your Honor, it's our understanding he needs to be transported here. There is no plea agreement.
Yes, ma'am.
If I could have 1 second with Mr. Flowers before we conclude Mr. Tran's case, if we could just recall Mr. Flowers in a second.
I'm happy to wait, Your Honor. Thank
Yes,
you.
sir. Okay.
Your Honor, I believe that's all I have on other matters. But thank you, sir.
Yes, sir, thank you. Mr. McKevichus, are you ready?
Yes, Your Honor.
Please.
Good morning.
Good morning, sir.
Joseph McKevichus for the record on behalf of Carlos Mejia. I know we requested his presence here today, but we have negotiated a deferred prosecution agreement that's been executed, and Mr. Gomez was fine with my client going back to work.
We wanted to put one thing on the record just because this originally was charged as a burglary. Upon the state reviewing the evidence, we do not feel as though there was intentional crime therein, and so we would reduce the charge to a misdemeanor trespass. And that is what we were entering the DPA on. We just wanted to make sure that was clear for the record so that in the event this DPA comes back, it's not confused with a burglary. It still would be for the trespass because the state doesn't feel like we have the evidence to prove the burglary.
Madam Clerk, do you need an amended information or that's included and that's it?
That's fine.
Good. Yes, sir.
This is the
And Your Honor, I did.
It's signed DPA, so it'll fall off the docket.
It is an executed DPA by the defendant, the defense counsel, and the state, Your Honor.
And Your Honor, I did review that with Ms. Mejia, with Madam Interpreter. She was nice enough to come here today just for this, and we did review it with them.
Lisa, do you have any other cases today?
I do not, Your Honor.
Thank you, ma'am. I'm sorry that
Thank
you
you.
wasted your time. Thank you.
Thank you, sir.
Yes, sir.
Thank you very much, Your Honor. Nothing further.
Yes, sir. Thank you. Yes, sir. Mr. Morrow, you ready?
Yes, Your Honor. Ryan Morrow from Mr. William Becker. He has 4 matters before the court this morning, Your Honor. They're all VOP. He's before the court on a purely financial affidavit. We're asking the court to allow us to continue this to a miscellaneous day in late August to afford him another opportunity to finish it out. And if he's able to do that, we'll ask the state to move the court to dismiss the affidavit at that time.
From the state, any objection?
No objection, Your Honor.
Mr. Becker, do you agree to the continuance?
Yes, sir.
I'll see you back here on September 11th at 9 o'clock. Oh, okay. No, I won't see you on that date. Let's give you another one. All right, so how far out do you want to set it, Mr. Becker?
What's the latest date Your Honor has in August?
August 24th.
That's what we'd like, Your Honor.
Okay? August 24th at 9 o'clock.
Okay, thank you.
Thank you, sir.
Your Honor, may I approach before I ask you? Excuse me.
Yes, sir.
and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris.
See, Mr. Collins, are you over there because you're open now? Call me next.
I'm working on some, but I do have one I can talk. He's ready.
Wait a minute, what about Miss Jakewood is on Zoom? Miss Jakewood, are you ready?
I am, Your Honor, and I apologize for appearing by Zoom. My son has a doctor's appointment this morning.
Okay.
I was informed that the court moved Mr. Ross's case, that's 22 CF 2558, to today's docket, because he showed up several hours after I had left on Monday. Mr. Ross sent me an email this morning with a letter indicating that he had COVID symptoms. I did not, however, receive any test results or anything. I did forward that letter to Ms. Davis for her review, but Mr. Ross will not be attending today.
Okay. Yes, ma'am. Ms. Davis.
Judge, the test that was done was a test.
And the Bulldog bail bonds?
It actually was not a test. It was just a report of COVID-like symptoms and that he should go get more testing. It was dated from yesterday. At this point, the state's concerned if Mr. Ross is habitually late for court, and it does not seem that he has sufficient communication with his attorney to move the case forward. So at this point, Judge, we would ask for a capias for Mr. Ross. There's no confirmation that he has COVID to excuse his appearance today, so at this point, we would ask for a capias.
Ms. Jacob, when was Mr. Ross put on notice of the hearing today?
I told him to be here today on Monday when he appeared because I had already left, I already completed my cases. I believe he showed up either just before or just after lunch.
So the state seeking the capias against Mr. Ross?
Yes, Judge, and just for Your Honor to be clear, he didn't show up until after 2 o'clock on Monday.
Okay. Thank you. A capias will be issued for Mr. Ross. I hesitate to ponder whether it should be without bond or whether the first appearance judge should be removed.
I would just ask that the first appearance judge address the issue at this point.
Thank you.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, ma'am. Thanks, Ms. Jacob. Mr. Vyers, you ready?
Yes, sir, Judge. Spoke with the state. She was kind enough to bring me up to speed. The train matter will be placed on 9/11 if it's fine with the court, and the state was going to announce something.
Judge, at this point, we're going to withdraw our current offer for a concurrent sentence with Mr. Tran.
And we were aware of that fact, Your Honor, but if it's fine with the court, put it on for 9/11. I'll communicate that with Mr. Patel's office this morning.
Let's continue.
Judge, thank you, sir.
Thanks, Mr. Vyers. Now I've got at least a few pro se's. Jonathan Wanzenack.
Your Honor, that was the case with Mr. Weinstock.
That was Weinstock, wasn't it? Kelvon Paris. Who was Mr. Paris? 23. Okay, Mr. Cruz.
Good morning, Your Honor.
They don't have you down, Mr. Cruz, for some reason. I don't know why.
There's a notice to appear in one of the cases first. He has filed a notice of appearance in one of the cases.
Okay, are you going to appear for Mr. Paris in this case?
Yes, Your Honor. I'm the attorney of record.
Okay. Paris, and you don't show up. Now that we'll put you in.
Yeah. I've appeared multiple times before you on Zoom.
Yes, sir. Mr. Cruz, what do you want to do with Mr. Paris's case today?
Your Honor, at this time, the defendant wishes to withdraw the previously entered plea of not guilty. We're going to be entering an open plea with the understanding with the state with a cap of 36 months that allows the defendant to present mitigating evidence for a downward departure. After the plea, we'd ask the court to order a pre-sentence investigation and a psychological evaluation, because we believe that that will provide additional information to the court for sentencing.
Okay. A few things that I want to address. Mr. Paris, when prison's a possibility, I want it in writing, so that's the first thing. Mr. Cruz, maybe ask the PDs for a plea agreement form. Mr. Paris, I want you to go through that, read every word of that. Because when you come back today, this morning, I'm going to ask you if you've read it and if you understand it, okay? So, Mr. Cruz, you'll need to fill that out. So that's one. Two is PSI, fine psychological evaluation. I've never had anybody ask the court to obtain a psychological evaluation before sentencing. I think if you want to obtain a psychological evaluation before sentencing, and I don't think the court orders that. I would be making some kind of judgment at that point. So, anything else from the state that I need to tell Mr. Cruz before he fills out the proposed plea agreement and we come back this point?
No, not to my knowledge, Your Honor.
So, Mr. Cruz, if you'll fill that out, then take it back or send it back with your client after you've done that, and then after he's read it and you've talked to him about it, then if you'll come back. Okay?
Yes, Your Honor.
Good. Thank you. Raul Silvas is next. Raul Falcon Silvas Jr., 21 CF 13, 21 CF 1311. Yes, sir. Good morning, sir.
Hey, how are you?
Good, how are you?
I'm good, I'm good.
Does the state have an offer for Mr. Silvas?
Judge, we had set this off for Mr. Silvas to get a little bit of progress done, but I'm not sure the status where we're at.
My hours weren't put in by mistake. They're all taken care of now.
Okay, hold on one second. Probation standing up. Maybe they can cut to the chase.
Yes, sir. I'm actually Mr. Silvas' probation officer. If I could speak regarding Mr. Silvas.
Please.
Would you like me to approach your stand?
You can stay there.
Okay. Mr. Silvas provided me all the community service work that will complete his conditions, and he's also going above and beyond being able to work off his Courthouse with community service work. I've been trying to work with him in order to get his driver's license, and that is the linchpin in which we need to get him successful. I've reviewed his file and his previous times on probation, and I honestly want to say in front of the court, Mr. Silvas has been doing an exceptional job, Your Honor, and I really want him to be able to succeed through this. But the problem is being able to get his monies out of collections so he can work that off. He's been doing an exceptional amount of community service work so that we can press forward with that.
Okay. First, Mr. Silvas,
Yes.
I don't think I've ever heard probation say exceptional job. If I have, certainly not with the emphasis that was given today by your probation officer, so that's outstanding. As far as the driver's license, so is that the term of the supervision?
It is not, Your Honor. That would be a quality of life that would be able to help him excel and exceed past where he needs to be in supervision.
So what is left for him to...
He has his DUI school, which he's been battling ever since he was placed on probation. It keeps coming back to the fines that are in collections in order to pay that off to get his license to be able to do the DUI school, which he has completed multiple times, and he's got to run around a bunch of times on it. We've been fighting to get that completed. That's really it, aside from the monetary obligation, which we're working on with the court costs and community service work, Your Honor.
Okay, so how long do you think it'll take Mr. Silvas to complete? How long should we extend probation?
I would say 2 years, Your Honor, considering the amount of community service work he's doing and at the minimum rate of $11 per hour. I believe he'll be able to pay his fines off fairly quickly. My concern is just him being able to pay off his money that's in collection.
And has the cost of supervision previously been waived?
No, sir. If we could waive that in the arrearages, I think that would put him even more forward in being in a better spot.
Yes, sir. To the state?
Judge, if I can just have 1 second on Mr. Silvas, because I don't necessarily want to set him up for failure or being on supervision longer, so give me 1 second.
Yes, ma'am.
Judge, at this point on Mr. Silvas' case, the state's going to dismiss the violation and reinstate his supervision. So my understanding is he won't terminate until 2024, so he's got a little bit more time to complete things.
Any objection to the court waiving the cost of supervision both retroactively and prospectively?
No, Judge.
Mr. Silvas, what you've seen is very rare, and it's because of all the effort you put forth. I'll say the system, but I mean, it usually doesn't work this way. And I'm really proud that it is in your instance. So the court does waive the cost of supervision, their arrear, what's in the past, and you don't have to pay that in the future. Okay? So the violation of probation is dismissed, and your current supervision is reinstated. Okay? What early termination if he successfully completes everything?
Yes, Judge, we wouldn't have any problem with that.
So once you fulfill all of your requirements, then your supervision will terminate if that's early. Okay. Thank you, sir. Thank you. Mr. Sellers, I see you on Zoom. Well, I did see. There you go. Hello, Mr.
Yes, sir, Judge. How are you today?
Doing well. How are you?
Good, thank you. We're here on Mr. Blackshear, Judge. This is really just for purposes of appointing the expert for the updated competency eval. Last time the problem was he didn't meet the criteria for involuntary hospitalization, and then he didn't cooperate fully with the competency restoration with him just in the community so he could work and stuff. So he was committed, and unless he meets the criteria for involuntary hospitalization, he has to be committed to.
Mr. Summit. Mr. Blackshear in back.
Frank Blackshear.
Let's wait 1 second and bring in Mr. Blackshear.
Yes.
We can hear him. Hello, Mr. Blatcher. Hello. Your attorney's on Zoom. He was just starting to bring me up to speed on the need for the competency evaluation. Yes, sir, Mr. Sellers.
Yes, Judge. So, since it's been longer than 6 months since the previous evaluation, we need another evaluation so that the court can make a determination how best to proceed. If he doesn't meet the criteria for involuntary hospitalization, he would have to be committed to the custody of the Department of Children and Families, which would do the remediation locally for competency.
Okay. So I do appoint an evaluator to update the evaluation for Mr. Blackshear. Mr. Sellers, will you prepare that proposed order?
We did, Judge. We e-filed it. They said that Randy McDonald is the one that's up on the list that is doing those over there now.
Okay. Okay, so I will look at my break, at the break this morning, and then at lunchtime, and sign that order.
Thank you, Judge.
Okay, so we're going to bring Mr. Blackshear back on September 11th. Or do you want to bring him back before that, Mr. Sellers?
Judge, if we can get the evaluation before that, would the court have any objection if we just coordinated to have it brought in early?
Not a bit. Yes, sir. So, Mr. Botcher, I'll see you no later than September 11th. Yes, sir, Mr. Botcher.
I've been here 11 months.
Yes, sir.
I've been dealing with this case for 4 years and 2 months. I can't get no time served, like, or no 2 years, 3 years probation with ankle monitor or nothing.
The state's not offering that. I can't make the state offer something. You'll have to listen to your attorney, Mr. Sellers, as far as what he can move the court for. I'll respond. I have to play the hand that I'm dealt. I can't just dream up what the cards are.
I'm not a menace to society. I ain't kill nobody.
Mr. Blackshear, if you are found competent, we can proceed and get the case resolved. If you're not found competent under Florida law, they have to restore your competency, because the essence of it is that you don't appreciate the nature of your actions or the consequences of your actions and are unable to assist your attorney in preparing a defense. So once we have this evaluation, we'll know exactly which way we need to go.
Thank you, Mr. March. Thank you,
Thank you, Judge.
Would you take Herbert Schmidt on the 230 docket for a meet with Mr. McKinney? He's ready. Schmidt, Herbert Schmidt.
Mr. Herbert Schmidt Jr. is before the court in 22 CF 416. Judges, Mr. Schmidt joins me at the podium. We did review a written plea agreement at the jail. We did discuss it at length. There were some of the things on here are redundant that were added by Ms. Berickman, but I wanted to make sure that since there was a change to the document, Mr. Schmidt knew exactly what it was so he can initial it.
Okay.
It's just an initial that you are aware of that these things are written on, so just need an initial right here. And for the record, Mr. Schmidt Jr. in 22 CF 416 has initialed the write-ins to the plea agreement. The terms and agreement that it's agreed upon with the state is that Mr. Schmidt Jr. would be entering a plea as charged in count 1. Counts 2, 3, and 4 will be dismissed by the state. He will be adjudicated guilty, placed on 24 months. He'll be placed with the Department of Corrections for 24 months. with credit for all time served, followed by 7 years of sex offender probation. The special conditions of that probation include sex offender counseling. He must forfeit any seized devices, GPS monitoring set at a minimum standard rate, no internet capable devices with exceptions for work, school, any other exceptions allowed by probation. He was allowed to have a basic cellular phone, no unsupervised contact with minors. There is a 10 p.m. to 6 a.m. curfew which relates to the sex offender probation. $667 in court cost, $150 cost of defense. We're asking the court to waive the cost of supervision for Mr. Smith. If the court wishes to inquire about his financial status, I believe he's on fixed income. This is a guideline sentence. No objections or corrections to the score sheet as provided, which is 56.2. So this is within guidelines. May I approach with the plea agreement?
Yes, sir. Mr. Smith, if you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. You can put your hand down. Mr. Smith, are you currently under the influence of any drugs, alcohol, or medication? No. Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No.
How far did you go in school?
3 years.
Did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
I believe he did.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Do you understand that if I accept your plea, that you're waiving the right to a trial by jury?
Yes.
Do you believe it's in your best interest to enter the plea?
Yes.
Are you entering the plea today freely and voluntarily? Has anyone forced, threatened, or coerced you into entering the plea?
No.
Has anyone promised you anything other than what's in the written plea agreement?
No.
The other side of that, has Mr. McKinney or anyone else said, Mr. Schmidt, if you fail to enter this plea, you shall be sentenced to 10 years in prison or any other definite sentence?
No.
Mr. McKinney, I think you stated 56.2 months.
No, it was 24 months followed by 7 years probation.
But when you were just saying what the score sheet shows.
It's not months, points.
Okay. So it's 21.15 months.
Correct. It's a guideline sentence, but the agreement is for 24 months Department of Corrections followed by 7 years probation.
Okay. Just wanted to make sure.
Yes, sir.
Mr. Schmidt, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty of count 1, counts 2 through 4 are dismissed. You're sentenced to 24 months with the Department of Corrections with credit for all time served. That's followed by 7 years of sex offender probation. You have the special conditions of sex offender counseling. The seized devices are forfeited. You need to wear a GPS monitor. Have no internet-capable devices, with the exception for work, school, or other exceptions allowed by probation. That would mean that the work or school also needs to be approved by probation before you use it for that. You can't have a basic cell phone. Have no unsupervised conduct with any minors. There's a 10 p.m. to 6 a.m. curfew. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You need to pay $150 public defender's fee. Mr. Schmidt, before you were incarcerated, how much money were you making per month?
Almost 800.
Okay. I do waive the cost of supervision.
It's somewhat redundant, but Mr. Schmidt would be designated a sexual offender by entry of the plea.
Yes, sir. He's designated as a sexual offender. Mr. Schmidt, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes.
Thank you, sir.
You're going to get.
I believe I have one more pro se on the docket. Is it Heiser Timms? Mr. Timms? Please, Mr. Timms. 23 CF 1161. So, Mr. Timms, I appreciated your letter, where it says that you missed coming on July 13th, that you came here on the next day at 9 o'clock, thinking that was the day. That's what I highlighted. Hold on one second. That's what made the difference, and that's why I said, let's just get Mr. Timms here. I don't know, Madam Clerk, issue of habeas corpus.
You did, but you recalled it.
Perfect. Great, Mr. Timms. I want to make sure they didn't arrest you because you were here the next day. That means a lot. On Mr. Timms' case, is there an offer to Mr. Timms?
No, Judge, he has a misdemeanor that will be merging into this case, so that's going to affect the offer at the end of the day.
Mr. Timms, do you want me to appoint a public defender if you qualify financially?
No, sir. I'm here by special appearance surgery. I'll be representing myself.
Okay. So, Mr. Timms, before you leave, make sure that the state has your contact information.
Yes,
so
sir.
they can communicate directly with you. I'll see you back here on September 11th at 9 o'clock. That's the pre-trial. We'll be talking about going to trial. We'll have at least 1, maybe 2 days between then and trial, if that's what you want to do. And we'll have a conversation about you representing yourself, okay?
Yes, sir. I do have more information that I need to present to you because there was a injury regarding your capias. Is that how I pronounce that?
The capias is, okay, there's no capias outstanding for you now.
I don't mean to cut you off, Your Honor, but I did lose my employment. I was terminated due to your capias because I do have I'm a subcontractor with the Department of Homeland Security. I work for the VPS Airport. And when I badged in the night of the 16th, the sheriff made me aware of the capias, and my employer terminated my employment that evening.
So do you need an order withdrawing that capias?
There was an order withdrawing the capias.
Order, but it appears that there's an arrest report with the capias.
Yes. Yeah, I was arrested.
Okay, so what do you need from the court to try to correct that?
There's nothing at this point that the court can do. I spoke with my supervisor, management, and I haven't spoke with TSA yet as far as my eligibility, but from where it stands right now, I'm not eligible for rehire. Your Honor.
Yes, sir. If you find, it's another reason why you may want to get an attorney. They may be able to help you in that regard. If there's something that I can do that says that I withdrew the capias because of what you filed, enter something formally, just let me know.
Yes, and I will honor that, Your Honor. I've tried to show this information to the sheriff the night of the arrest to sort of back them down off the aggression that they were showing me that night, but they were so aggressive with getting me to Crestview. Well, matter of fact, we came here to the annex that night. So, they were so adamant about getting me to the annex that they didn't allow me to present them no information in regards to my defense. So I was unsure about what to do about the situation. I'm still learning the process and the procedures, Your Honor.
Okay. To the state, regarding Mr. Jones, do you think I should go through the colloquy now about representing yourself? I certainly don't want to do it on pretrial because we'll have so many. If Mr. Jones doesn't want to accept the state's offer at pretrial, well, or even if he does, I guess then I need to ask you this question.
I think case law, from what I've seen, is, we have to do the inquiry every time that a pro se defendant desires to represent himself. We have to reestablish.
Okay. Mr. Jones, I've got quite a few questions for you.
Yes,
or
sir.
at least things that, yes, questions and things to say. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, under penalty of perjury, I state that all the information is true and correct.
Okay. Do you understand that you have the right to an attorney?
I do.
If you can't afford an attorney, one will be appointed for you. The state of Florida will pay for a lawyer to represent you in this proceeding. Do you want me to appoint an attorney to represent you in this case?
No, Your Honor.
Let me tell you some of the ways a lawyer can help you prior to trial. A lawyer's legal knowledge and experience may assist you in attempting to set a bond, reduce a bond, or obtaining pretrial release. A lawyer may obtain information about the case through skillful use of discovery. A lawyer may discover possible violations of constitutional rights and take the proper steps to address them. A lawyer may make sure the speedy trial rules and statute of limitations are enforced. A lawyer may identify and obtain favorable evidence to introduce at trial on your behalf. A lawyer can, if appropriate, file motions to exclude evidence, to suppress evidence, and to dismiss or reduce charges against you. Do you understand those rights?
Yes, Your Honor, I do comprehend that.
Okay, I'm sorry. Those advantages of an attorney.
Yes, I do comprehend that, Your Honor. Due to my research, I understand that by me hiring an attorney, I place myself under the court's jurisdiction. And that's what I'm not privileged to do at this time, Your Honor. I will represent myself in this matter.
I mean, my belief at this point is that you are under the court's jurisdiction because you were arrested, the charges were made, and you're here. So whether you're under the jurisdiction, I've never heard anybody say, I mean, if an attorney appears for you and starts taking action, then maybe that would subject you to jurisdiction. But my belief is that you're under the court's jurisdiction, just so you know.
Understood. I comprehend that, Your Honor.
Let me tell you some of the ways a lawyer can help you in deciding whether to enter a plea. A lawyer can advise you as to whether entering a plea is in your best interest. A lawyer has the expertise to help you work with the state and even bargain for different terms. A lawyer can tell you the advantages and disadvantages of what you might say to the court during your plea hearing and the sentencing hearing that will follow. Do you understand that you'll not get any special consideration from the court just because you're representing yourself?
Yes, I do comprehend that, Your Honor. Also, Your Honor, before we proceed with this matter any further, I would like the court and the prosecutors to certify my right to subrogation in this matter.
Subrogating to what?
Subrogating the matter as far as the charges that's brought against my state, Your Honor.
I've never seen a subrogation in relation to a criminal. Certainly seen that in insurance defense cases, but I haven't seen one, so I don't know what you're assigning to someone else that they can, I just don't understand how that works. So I'm not acknowledging that because I don't know what it means. Do you understand how necessary a lawyer is and how he or she could help?
Yes, I do comprehend that, John.
You're currently charged with, what is he charged with? Mr. Tim, charged with unauthorized possession, blank forged, stolen driver's license, correct?
Yes, Judge. There's another charge in misdemeanor court that will also be merging in later. I want to think there's a DUI. Madam Clerk, can check the misdemeanor case.
Okay, but that's not before we...
Not yet. It will be.
Can I pose a question, Your Honor?
Yes.
With the charges that she just mentioned, as far as DUI, Your Honor, I've never been arrested for driving under influence at no time. I do not have a driver record.
It was a financial responsibility to attach a license but not a sign and driving while license suspended.
Good. Yes, sir, you're right. Thank you. So in this case, have you received a copy of the charges against you, the charge against you for unauthorized possession?
I believe I have that. Also, Your Honor,
okay. You haven't received the information.
Oh, I haven't?
It's set as a felony plea day today. We reset it.
Good. Madam Clerk's going to give you a copy.
Okay. Also, I do have the copy of the arrest report when I was initially arrested, and it doesn't show any information in regards to a court date on the 13th, I believe it was.
Okay.
I have no information of that court date also.
Okay. So for the record, you're being handed the information. That's the charging document from the state. It says that you're charged with that unauthorized possession, blank forged or stolen driver's license. So that's why you're here, okay?
Okay, yes, I understand, but what I'm saying is the failure to...
I understand on the failure to appear, you're
yes,
saying the only thing that gave you that day.
Right, I didn't have any information that day, as far as court date goes.
to the state, what's the maximum sentence that Mr. Jim could be sentenced to?
Judge, at this point, it should only be an 1129. I know it's a third-degree felony, but I don't think that he scores sufficient to go to 5 years further.
Okay. Mr. Jim, so do you understand if you're found guilty, you could be sentenced to 11 months, 29 days in county jail?
Yes, I comprehend that, John.
Hopefully this is final. Maybe not. Yes. Let me tell you some of the ways that a lawyer can help you with a trial. A lawyer has the experience and knowledge of the entire process. Your lawyer will argue for your side during the whole trial and present the best legal argument for your defense. Since jury selection is governed by a lot of legal procedures, the lawyer's knowledge and experience may give a lawyer an advantage during the selection process on your behalf. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, consequences of that decision, and what you have a right to say or not say. A lawyer has studied the rules of evidence and knows what evidence can and cannot come into the trial. A lawyer can make objections during the trial to try to keep certain testimony and evidence from being introduced at the trial. A lawyer may provide assistance in ensuring that the jury is given complete and accurate jury instructions by the court, may make effective closing arguments on your behalf, and may prevent improper arguments by the prosecutor. A lawyer may ensure that any errors committed during the trial are properly preserved for appellate review later by a higher court. Do you understand all of those advantages of an attorney?
Yes, I comprehend that, John, and I would like to explore the option of having an attorney represent me.
Okay. How much money do you make per month?
How much money did I make per month when I was employed? I would say at least, let's see, $2,100 a month.
And now you're unemployed.
Yes, that is correct, Your Honor.
So I would appoint the public defender if you want an attorney. There'd be a $50 application fee and then a $100 representation fee, but it's a flat fee of $150.
Okay.
Do you wish for me to appoint the public defender?
How soon would I have to pay the balance on that to be represented?
At the very end, if you're found guilty or if you enter a plea.
I explore that option. Yes.
Yes, sir, Mr.
Jason McKinney. For the record, I'm providing my contact information at this time. Just so the public
Okay.
We would acknowledge the receipt of a one-time information, waive its formal reading, and enter a plea of not guilty. Madam Clerk, when is the next court date for Mr. Thames? September 11th at 9 a.m.
I have some get in the office this week.
It's also set for August 14th for his misdemeanor case.
There's a misdemeanor court case set for August 14th.
Correct.
Is that at 9 a.m.? So you need to appear at that date as well, or something.
I'll give you a call.
Mr. Gates, you ready?
I am, Your Honor.
Please.
Thank you.
I'm good to go. Thank you, Your Honor. Appreciate your patience.
Thank you.
Have a good day.
You too.
Good morning, Judge. Your Honor, before the court is Dustin Leviel. It's case number 2022 CF2581. I have a plea and sentencing agreement in my approach.
Yes, sir. Thank you, sir. Good morning. Mr. Leviel, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Raise your hand up. Just give me one. Mr. Leviel, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
So you're going to enter the pretrial intervention program, right?
Yes, sir.
If you successfully completed, your case is dismissed. What else do you need to do, Mr. Gates?
I think that's all we need to do, Your Honor. Mr. Leviel will be going to probation right after court.
Okay, so he's already been accepted into it?
No, he's not been accepted yet. He's going to meet with him this morning.
Okay.
And so we'll probably need a control date.
Okay. September 11th at 9 o'clock. But if the paperwork goes through, you don't have to be here then.
Okay. Yes, sir.
Stay in touch with Mr. Gates.
Yes, sir. Thank you, Jason.
Yes, sir. Are you ready, Mr. Freeman?
So, Frank just went downstairs, maybe a minute. That it takes on downstairs, Your Honor, so I don't have anyone back on need to be able to bring out his line.
Oh, that's right.
At the moment, it'll be just a minute or two.
Okay.
Right, so thank you.
Why don't we do Mr. Bryant's case? Ms. Sharpless, are you ready? And Mr. Medina?
Yes, Your Honor.
Good.
Thank you, Brian.
Yes, sir.
Can we get him out, Your Honor?
You can't get him in.
No, Your Honor, I don't have anyone back there.
Okay, correct that. Okay,
I certainly will.
please.
Yes, Your Honor, first I call King, okay?
Mr. King is present and approaching, Your Honor. I talked with Ms. Davis, and I believe, even though 22 CF 1368 is set for trial, there are two VOP cases that I think the better course of action would be to set those for the VOP hearings. And we can do that the first available date in August in preparation for resolving these cases here in the next month or two.
Is this state ready for VOP hearing?
Yes, Judge, we are.
August 14th or August 17th?
Then we'll go with Paris and the police Paris.
There are 3 set in the afternoon on the 14th, and on the 17th there are 5. So.
Okay, so August 14th and the 14th will be at 1:30.
1:30, okay.
Yes, sir.
I know now we're doing arraignments, it's always, okay. All right, so
I'll see you back here August 14th at 1:30. Thank you.
Next, Your Honor, I have Jeremy Mosley.
Your Honor, this is Mr. Mobley. He was on the court's trial docket. We have reached an agreement to resolve this case. At this time, Mr. Mobley is going to be entering a no contest plea to count 2. That's misdemeanor battery. In exchange for the plea to count 2, count 1 will be null prost. Mr. Mobley will be sentenced to time served. He will be assessed misdemeanor court costs, $150 in public defender fees, and he would be adjudicated of the misdemeanor. May I approach?
Yes, sir. Thank you. Mr. Mosley, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Did you read the plea agreement?
Yes, I did.
Do you understand it?
Absolutely.
Did you sign it?
Yes.
Mr. Mobley, I do accept your plea. Count 1 is dismissed. You're adjudicated guilty of the misdemeanor. Count 2, you're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. How long will you need to pay those amounts?
Can I do like 6 months?
Yes, sir.
And do we know what the amount for the court costs are?
Madam Clerk, on this one.
772? Okay.
So if you fail to pay that within 6 months from today, it'll go to the civil lien.
Okay.
Thank you, sir. Good luck.
Thank you. Thank you.
Yes, sir. Yes, sir. Please. Thank you, sir. So, Mr. Paris, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. So, Mr. Paris, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, Your Honor.
Do you believe it's in your best interest to enter the plea?
Yes, Your Honor.
Has anyone forced, threatened, or coerced you into entering the plea?
No, Your Honor.
Has anyone promised you anything other than what's in the plea agreement?
No.
And since it's a plea straight up, meaning there's no agreement with the state, do you understand that you could be sentenced up to a maximum of 20 years in prison?
Yes, Your Honor.
Your Honor,
we have a
we
sentencing
agreed
cap.
to a cap of 36 months DSC.
Perfect. Okay, good. So you understand you could be sentenced up to 36 months in prison?
Yes.
And I haven't made up my mind what I'm going to sentence you to. I haven't heard everything. And I want you to know the maximum downside. Is the state going to seek probation after that incarcerative sentence? Do you know yet?
To be honest, Your Honor, I think we want to get any psychological evaluation first before we make that determination. As of right now, though, we're only seeking a 36 months in the Department of Corrections.
But there's no agreement on the cap of probation.
That's correct, Your Honor.
So, Mr. Parrish, do you understand you could be sentenced to probation without going to prison or even after prison?
Yes, Your
It's
Honor.
a possibility.
Yes, Your Honor.
Okay. Do you have any questions for me, Mr. Cruz, or the state?
Not at the moment.
Okay. So, how far out? I do order a pre-sentence investigation. That takes about a month traditionally. Is that accurate?
Your Honor, if we're waiting on psychological evaluation, I would probably say at least 2 months.
Your Honor, we're going to procure the service of a private practitioner, so we'd be able to get that within a month.
Okay. But you've got to give that information to probation before they do the pre-sentence investigation. I mean, I can set it for a month out, but it may not be ready then.
Your Honor, I think it would be better to set it, like probation said, maybe 2 months out. That way, there's ample time for them to secure the psychological evaluation, as well as providing it to probation, giving probation ample time to write a pre-sentence investigation based on that evaluation.
And then if it comes in earlier, then you can schedule it before that.
Yes, sir.
And Your Honor, there was one thing I don't know if it was addressed in the plea agreement. If it wasn't, I apologize, but would there be any problem with reserving on restitution, Mr. Cruz?
No objection.
Okay. We would request reserve on restitution for 180 days.
So, Mr. Parrish, what they just added, and it's not in your written plea agreement, is the state wants to be able to ask for restitution. They want to ask for you to pay the money that is owed to an alleged victim arising from your crime. They don't know what that amount is. Do you agree that that would be part of the sentence? If you want to step back and talk to your attorney a second away from the mic, do that. Do you understand?
Yes, sir.
Do you still wish to enter the plea?
Yes, yes, sir.
Mr. Harris, I do accept your plea. I'll set your sentencing for September 14th at 2:30. Again, if all the paperwork comes in and everything's ready, Mr. Cruz can set it for a hearing sooner than that, okay? So no later than September 14th, I'll see. Thank you, sir.
Thank you, Your Honor. That concludes my business.
Yes, sir. Thanks, Mr. Cruz. You ready?
Yes, sir.
Yes, sir.
Good morning, Your Honor.
Good morning, sir.
Your Honor, Chris Garrett on behalf of Bridget Mazawi, case number is 22CF3103. I believe she is on Zoom up there.
Hello, Ms. Mazzelli. You need to unmute.
Hello, sir.
Perfect. Mr. Garrett?
Your Honor, we have worked out a PTI deal in this case. Ms. Mazawi was planning to be here, but she had a medical procedure and some complications. Maybe that's their case to be continued to, I guess, the pretrial, and we'll get the PTI entry.
Good.
That's correct, Your Honor. Just for the record, we have agreed to terms of that PTI specifically, so all we need to do is get it executed.
Good. Ms. Mazzelli, if the paperwork goes through on the diversion program, then you don't have to be present on September 11th. In case, you just don't have to be here then, okay? If something goes wrong, then you'll need to be here September 11th at 9 o'clock. Stay in touch with Mr. Garrett, okay?
Yes, sir. Yes, Your Honor.
Thank you, ma'am.
Thank you, Your
You're
Honor.
welcome.
Thank you. Your Honor, I believe that's all I have, Your Honor.
Thanks, Mr.
Thank you, Your Honor.
Judge, may I jump in with a few that are in the gallery?
Why don't we take a break, and then we'll come back and finish up the morning. So we're going to take a 10-minute recess.
All rise, please.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we
service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crest.
.072 subsection 3. She would also enter a plea of no contest as charged on count 3. The agreed upon disposition that she will be sentenced to time served. She will be assessed misdemeanor court costs, $150 in public defender fees, and she will be adjudicated of the misdemeanors.
What happened to count 1?
Count 1, I'm sorry, count 1's been no crossed. Yes.
Yes. So go in, if you raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Now you put your hand up. Ms. O'Gorman, did you read the plea agreement?
Yes, I did.
Do you understand it?
Yes.
Did you sign it?
Yes.
Ms. O'Gorman, I do accept your plea. You're adjudicated guilty of the misdemeanor. Count 1 is dismissed. You're sentenced to credit for time served on a lesser included offense in count 1 as charged in count 3. You'll need to pay the misdemeanor court costs, $150 public offender's fee. How long will you need to pay those amounts?
A few months.
I'm sorry?
Would a few months be okay, Your Honor?
Few months? 3 months?
Do you want 6? She asked for 6 months, Your Honor.
Okay, if you fail to pay it within 6 months, then it will go to a civil lien or judgment. Okay? Thank you, ma'am.
Thank you, Your Honor.
Good luck. Next I have Robert Matthias. Mr. Matthias is approaching, Your Honor. I believe the state's going to have an announcement in 23 CF 319.
Yes, Your Honor, at this time, based on the FDLE report that said that they could not exclude him, we're going to be dismissing the new law violation and therefore dismissing the DOP as well, and that would just reinstate back to probation.
In that case would be 21 CF 2064.
Mr. Matthias, 23 CF 319 is dismissed, and the violation of probation is dismissed.
Thank you so much, Your Honor.
Thank you, sir.
God bless you.
Yes, sir. Thank you. You too.
Judge Van Call, Robert Sargent. Mr. Sargent is before the court in 3 case numbers, 20 CF 2715, 22 CF 2645, and 22 CF 3041. I believe the most efficient use of our time here would be for the court to order APD to effectively give us an answer. If they do not give us an answer, then appoint an expert. Given that Mr. Sargent already has ties to APD, I don't believe that that is necessary, but there is an order that I can present to Your Honor that would appoint APD to determine intellectual disability or autism. And then that puts the ball in their court to give us that answer in an expedient manner without trying to circumvent and going and get an expert. I believe that they can make that determination going forward to try to bring this to a quicker resolution.
So I see the state's nodding, so they won't object.
No, Judge, Ms. McKinney had already forwarded it to me to review prior to today.
Yes, sir.
May I approach for that order?
Yes, sir. Mr. Sergeant, how are you doing?
Good, how are you?
Good. It's good to see you again, sir.
Good to see you.
Thank you. Mr. Sergeant, so I'm signing this. Somebody will come talk to you, and then after that, hopefully we'll be able to figure out a conclusion to your case.
Okay.
Good.
And Judge, given that order, I'd like to set this for a status hearing on the last date in August.
August 24th?
Yes, Your Honor, just as a status, if we get an answer in an expedient manner in the next week or so from APD, then we can always advance this on the docket to try to bring this to a resolution to determine where we're going to be going for competency training.
Okay. So August 24th at 2, you want it in the morning, right?
Yes, Your Honor, there would not be a contested hearing.
I'll see you no later than August 24th.
Okay.
Thank you, sir. Thank you.
Anna Segafredo? Ms. Segafredo is here in 23 CF 926. We have reached an agreement in this matter. The agreement with the state is for a lesser included offense in count 1, a felony battery, a third-degree felony. Count 2 would be a first-degree misdemeanor battery. The agreement calls for a withhold adjudication, 2 years of probation. To the state, would that be 1 year probation concurrent on count 2, the misdemeanor?
That's right.
Special conditions would include continue with anger management. She is already receiving services from Bridgeway. Continue with mental health treatment. She's also continuing that treatment with Bridgeway. No violent contact with the victims or any witnesses. Standard court cost of $867, $150 cost of defense. We would request that the court waive the cost of supervision, as I believe she's on a fixed income if the court wishes to inquire. May I approach?
Yes. Would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down. Did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
How much money do you make per month?
14.
1,400?
914?
Yes.
914. Okay. Ms. Segafredo, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation on count 1 to the lesser included offense, 1 year probation on the misdemeanor. That's to run concurrently, run at the same time. You need to continue with your anger management and mental health treatment. Have no violent contact with the victim or with any witness. You will need to pay the court costs, $150 public defender's fee, and the court waives the cost of supervision. Okay. Thank you, ma'am. Good luck to you. Yes, ma'am.
Joel Walls. Mr. Joel Walls is before the court in 21 CF 1796.
Hey, Mr. Walls.
Hey, how you doing, Mr. Brown?
Good. How are you?
Judge, Mr. Walls is currently on the trial docket, and we're here for jury trial review today.
Okay. So, yes, ma'am.
Judge, at this point, the state's going to have to ask for a continuance. In Mr. Wall's case, the main arresting officer now lives and works out of state. We're going to have to make travel arrangements to get him here. We've reached out. He is not able to make it for the 2 trial weeks that we have. So at this point, we're going to have to make arrangements. We've floated him down before. He is willing to do so. We just did it in June for the motion to suppress on Mr. Walls' case. So I don't anticipate this being a continuing issue, but with the short notice between, Mr. McKinney and I had just talked on Friday afternoon that we would be setting this case for trial. So then we started trying to contact Officer Litty immediately, and he's just not available with a short notice to get here in time.
We lost that week because of power outage, right?
That's a big part of it. I don't know that it would have changed with, just a couple of weeks of trying to get his travel arrangements made to get here for this cycle, so.
Mr. McKinney?
Judge, we understand the travel predicament. We're not going to necessarily object to a continuance.
So, do we want to come back on September 11th?
Yes, Judge. We should be able to make the travel arrangements between now and then so we can have a hard date for the court, even when we get to pretrial, of what day of the trial cycle that we will have the trial next time.
I anticipate that we're going to be announcing that this is on the trial docket at pretrial. May we waive his appearance at pretrial, understanding?
Is that okay?
Yes, Judge.
Good. So, Mr. Walsh, you don't have to be here on September 11th at 9, but you do need to be back here on September 18th at 9 o'clock.
Okay.
Stay in touch with Mr. McKinney if anything changes.
All right.
Okay? Thank you, sir. So it is continued.
Eric Watkins. Mr. Watkins is approaching in 21 CF 2598 with a felony violation of probation. The basis for the violation of probation is a new misdemeanor that we were hoping would be resolved by now. We passed it over several times in hopes that that case would go to trial in misdemeanor court to save us from doing an evidentiary hearing. Given that that has still not happened, I guess I'll defer to the state whether or not we want to schedule this for a contested evidentiary hearing from this point or not.
I would say let's go ahead and schedule it for a contested hearing for probably the last date of August, just to make sure that we have enough time between now and then to see what happens.
I would be fine with that, Judge. We will set it in the afternoon of the 24th.
Mr. Watkins, I'll see you back here August 24th at 2:30, and we'll have the judge trial, basically. Okay? Thank you, sir.
Come talk to me. Judge, I have a matter off the docket, but in the gallery, may I call that?
Yes, sir.
That is Mr. Kasem Wright.
Mr. Wright.
Mr. Wright is present and approaching in 23 CF 618. Mr. Wright accepted the plea agreement and was placed on probation at, I believe, on pretrial. So docket day, pretrial, whatever you call it, since it was the same thing in one day. But part of his terms and conditions was no contact with the victims, no trespass at their residence. I've been in contact with the victims who've been vehement in telling me that they want to have contact and they want Mr. Wright to be present at the home. So I would seek orally to modify the probation terms to no violent contact for the two listed victims in the case, and to delete the no trespass condition of his probation. I don't believe that the state attorney has an objection. However, I certainly don't want to put words in the state's mouth.
Yes, sir.
Judge, when we did the plea on Monday, we were operating on the information that we had at the time, with the new information that the victims don't object to having contact with Mr. Wright and allowing him at the residence. And the state really has no further position on it.
Okay. Mr. Wright, your motion is granted, so it'll be no violent contact with the alleged victims, and the no trespass is removed or deleted, so you can go there.
Yes, sir. Thank you very much.
Thank you, sir.
Kasem Wright, K-A-S-I-M. Wright, common spelling, that's 23 CF 618.
Who's his officer?
Brown.
Thank you, sir.
Judge. Thank you. Have a good day.
Yes, sir. You too. Can anyone else in the gallery?
I should have Michael Wilson. Mr. Wilson.
Michael J.C. Wilson. I don't see Mr. Wilson. This was noticed for 9 o'clock. It's 10:55. What is it? Okay. No bond capias will be issued for Mr. Wilson.
Yes, sir.
Then we want to, yes, sir.
Morning, Judge.
You got somebody in the gallery?
Yes, Judge. Thomas Koch for the record. This is off the docket. Can we address this briefly, Judge?
Okay. Yes,
It's
sir.
first name Kiyomara, last name Ramirez. who's present and approaching Judge. This is 23 CF 622.
Okay.
And Your Honor, this was set for the 7/17 pretrial. And of course, she was present on the 7/10 and got confused with the dates with the power outage.
Okay.
I'm requesting if we could remove the KPS and reinstate the bond.
Any objection from the state?
No, Judge.
Okay. Your motion is granted, so the KPS is withdrawn and the bond's reinstated. Will I see her back on September 11th? It's a new case or is it a deal? Okay. September 11th at 9 o'clock, okay? So, thank you, ma'am. Stay in touch with your attorney. Thank you, sir. Mr. Sharpless and Mr. Medina.
Thank you, Your Honor. Can we get Mr. Bryant?
Yes, sir, Mr. Bryant.
Your Honor, Ms. Sharpless and I discussed the possibility that we may need to approach when he gets here with him to discuss an initial matter.
Okay. Mr. Bryant's case number is 22 CF 2925.
Yes, Your Honor. Your Honor, could we approach with Mr. Bryant?
Mr. Bryant, go ahead.
Fort Walton Beach and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area.
Your Honor, may I just say a couple things before we proceed?
Yes, sir.
Steve Medina for Roderick Eugene Bryant, 22 CF 925, and we are here for a Nelson hearing. As a preliminary matter, I just wanted to note for the record that the motions to dismiss hearings that were subject, I think, of the Nelson hearing, those were matters that were before Judge Ketchel. Just putting that on the record. But if he wants to proceed, he did file a motion for Nelson hearing. Even though he has been in later contact requesting things from me that might imply a desire for me to continue to represent him, and we did try to preserve the status quo by following through with some depositions that he's requested transcripts for, and by dealing with a motion for recusal issue that was time sensitive. Other than that, I've basically been maintaining the status quo, but I have more recently received written correspondence from him indicating that he was doing a referral to the Florida bar about me, so I don't know what his current state of mind is as to my effectiveness. Thank you.
Mr. Barton, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. So, Mr. Bryant, I did do my homework. I read through, and the first line kind of summarizes it, and I highlighted it. And it says, I, and then states your name, would like to discharge my attorney, Stephen Medina, and then later in one of the other motions, would like to file a Nelson hearing. So, in order for, first off, do you still want someone other than Mr. Medina to represent you?
Yes, sir.
Okay. In order to grant that motion, I have to find that Mr. Medina is rendering ineffective assistance of counsel. So tell me what evidence there is that you believe the court can find that. So tell me what you believe Mr. Medina has done that's ineffective or that he hasn't done that's ineffective.
He hasn't challenged the probable cause, sir.
He hasn't countered the probable cause?
Challenged the probable cause. The probable cause of me being arrested.
Okay.
He hasn't challenged it.
Challenged it.
Yes, sir.
How do you believe he needed to challenge it?
Because I haven't done anything wrong. I'm in jail for nothing, basically.
Your Honor, I know that...
Wait, hold on. Let him finish first. Okay. What other reasons do you believe Mr. Medina has rendered ineffective assistance of counsel?
Other times we've been in court, he's spitting in 3 motions at one time, and the judge is asking him why are we here today, and he's telling me I'm getting a bond reduction, or I may get out on bond. I haven't been able to be make bond because my bond is too high. My family needs me at home. We lost our place and got an RV now. I got kids that need me at home. I'm in a bad bind right now, trying to take care of my family because I kept 2 jobs. I probably lost both of them since I've been here. I feel like I'm being falsely accused for something I never did. I was in a whole other county. When
Your Honor, I know that I'm not supposed to interrupt, but I would respectfully request that he be instructed that everything's being recorded, and if he's discussing the facts, that may not be in his best interest.
I agree. Just know, Mr. Bryan, that everything is being recorded. The state sitting to your right, it can't be used against you.
Yes, sir.
Talk about anything factually about your case. Any other reasons why you believe Mr. Medina has rendered ineffective assistance?
That's it.
Mr. Medina, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. So, Mr. Medina, what I wrote down was that you haven't challenged probable cause and that you haven't obtained a bond reduction. And
Yes, Your
the
Honor.
third thing was he's falsely accused.
Yes, Your Honor. If I might address the first and the third issues, because I think they dovetail. Basically, if we could have sought an adversarial probable cause hearing, I would have loved to do that. Under the rule, based on the timing of the state's information, which was filed on the 21st day, there was not an avenue open for an adversarial probable cause hearing. So I couldn't do that. What I did do was file a admittedly very creative motion to dismiss tied into the another District Court of Appeals case with respect to the language of the statute of limitations that was raised by the state that allegedly there was an act that quote-unquote resulted in death. So I won't go into the facts or the law on that, but I vigorously, frankly, there's no question in my mind that I was zealous and within the bounds of the law, doing everything I can for this man and his family. I and my investigator worked really hard on it. I advised him prior to the hearing on the amended motion to dismiss that was dealing with these complicated issues, that it was frankly of the nature of the Hail Mary, that it was also dovetailed with a amended bond motion. Judge Ketchel kept the bond issue under advisement. I also filed a motion to try to exclude the autopsy report. That also is kept under advisement. So basically, if we can go forward, it's my intention to get a medical expert on what could potentially be a significant Daubert issue that in essence was, because we filed, my third motion was a motion to exclude the autopsy report. Judge Ketchel felt that was premature, was not willing to make a decision, certainly in his favor on that issue, so we held it open.
So it's not under advisement, he just continued it, basically?
He basically continued it. Advisement is technically incorrect, but basically he continued the motion to exclude the autopsy report. I think it's next week, an autopsy records-related deposition of the medical examiner's office with Ms. Sharpless over in Pensacola. So I want to proceed on that issue. And the reason why I focused on that issue strategically, again, was because of a District Court of Appeal decision that I thought might give us a chance to bring up issues factually outside of the normal constraints of an adversarial remedy that wasn't available to us.
Okay, and you mentioned the bond, an amended bond motion was under advisement?
Yeah, that's in essence the same thing. The court continued that issue as well, because the issues did relate to each other.
Okay, thank you. Mr. Bryan, anything else you want me to know?
No, sir.
Mr. Bryan, I do not find that Mr. Medina is rendering ineffective assistance of counsel, so your motion respectfully is denied. So Mr. Medina and the Public Defender's Office will continue to represent you. So I see Mr. Bryan on September 11th?
Yes, Your Honor.
I'll see you no later than that.
And I will be in to see him as soon as I can to update him on some things, Your Honor. Thank you.
Thank you, Ms. Sharp.
Thank you, Judge. That's my only case for today. May I be excused?
Thank you, Your Honor. May I be excused as well? Thank you, sir.
Somebody's on Zoom.
Thank you, Deputy.
Ms. Benford? Don't forget her. Hello, Ms. Benford.
Hello.
Ms. Benford, who is it? You that's representing?
It's her son. Her son is in custody.
And that's your client?
Yes, sir. Yes.
Mr. Client, please.
Mr. Dunford is present, Your Honor. This is 21 CF 2204. We have Mr. Dunford on today's docket. We were hoping to have Dr. McDonald get an evaluation done for Mr. Dunford. However, she has not been able to do that at this point. I think that the appropriate thing to do would frankly be to set this off a matter of several months. I don't anticipate it taking several months to get the evaluation, but I do know that Dr. McDonald has, she testified in front of this court last week. I'm waiting on Mr. Merkwa's report. I know other people in my office are waiting on reports. I don't know what the workload is looking like. I don't think it's prudent to just say, put this on August 14th, because I don't expect there to be any update on this.
But you can and will move it up if you have.
Absolutely, absolutely. As soon as I get the report, we'll put them on the first available docket.
Okay. So do you want it for the end of August, beginning of September?
I would, if the court would pick one of the middle September dates.
Okay. The only day I think I've got, well, I've got two. September 14th. You want it in the morning?
The morning would be fine.
So, Mr. Dunford, I'll see you no later, and it sounds like it's forever. September 14th at 9 o'clock. But I trust that Mr. Kleins will move that hearing up if he's information. Mr. Denver, before you leave, you look at that camera, do you recognize those folks that are on the screen?
Yes.
Good. You want to say hello to them?
Hi.
Happy early birthday.
Oh, happy birthday, man.
Thank you so much. Thanks, Sean. Thank you. Yes, sir. Oh, I'm sorry, folks in the gallery. Yes.
Your Honor, this is Mr. Phillips. We do remain ready for trial in 21 CF 2816. I don't know, does anybody say anything for, is one of the rights around first?
I cannot go first.
That's fine. Whatever.
Judge, we've been trying, there's quite a bit of moving pieces in this case. I don't want to say, I can't, right at this moment, I can't pick a particular day in the second week that we would be available. I just know right now, this case, in all of my witnesses, the one that seems to be common is that the second week is more available. I just need to get up with a couple more individuals, one of them being the victim. I told him, if you recall, we actually continued this case last cycle because the victim was out of the country. I told him at that point the trial dates and that he needed to be available for one of those 2 weeks. I'm continuing to try to get up with him. I would just request, I think we want the second week. If you could give me maybe 24 more hours, I can have something a little bit more concrete in terms of dates of availability for that second week.
I'm certainly fine with that, Your Honor. The only thing is, I did not realize that there was a week between the trial weeks, and so the only day I'm not available the second week is the first day. Both of my kids have orientations at new schools that day. Other than that, I'm wide open that week.
There also is the matter, I don't know if we want to address this now, I know there's going to be some motions, there's a motion on that was filed yesterday afternoon. I don't know when we want to hear those. I would be completely okay if we would like to try to squeeze it in. I don't know what your schedule is like in that week in between trials, but
we've got continuing education through is most of that week. And so I'm not planning on being on the bench. I will work remotely some, but so I won't have time that week. Do you want to do it next week?
I was going to say, we could pop over next week.
Yeah, I would be okay with next week. I just need some time to prepare for those.
Sure. I'm available any day except for next Thursday.
Let's see what trials are set up for next week, and then let's just make sure before the end of the day that we figure out the time.
We can do that.
Okay. So, Mr. Phillips, which case is going to be tried?
It's the 21 CF 2816.
Okay. So, Mr. Phillips, at this point, I'll see you back here no later than August 7th at 8:30, but that's going to change. So Mr. Kleins will, well, why don't we say August 8th at...
That's perfect.
At 8:30, because we don't want to encroach on your day.
I appreciate that, and I'll be on call that entire week other than the Monday.
So August 8th, 8:30, but we're going to set that hearing for next week, the motion, and then we'll set the trial and get that firmed up. Thank you, sir.
Thanks, sir.
Your Honor, I have Christian Moore. And Mr. Moore is present, Your Honor.
Oh, Mr. Moore.
Sir. Mr. Moore has two cases, 22 CF 1817 and 22 CF 1830. At this time, Mr. Moore is going to be withdrawing his previously entered not guilty plea in 22 CF 1830. He's going to be entering a plea as charged on all 4 counts in that case. In exchange for the plea in that case, 22 CF 1817 will be no prost. Count 1 in the 1830 case is trafficking cocaine greater than 20 grams. That is a 3-year minimum mandatory sentence. Mr. Moore would be pleading to 36 months in the Department of Corrections on that count with credit for all time served. There is a mandatory $50,000 fine. Counts 2, 3, and 4 will be pleas as charged. Mr. Moore will be sentenced to time served on those. He would be assessed $615 in court costs on the 1830 case, $150 in public defender fees. He would be adjudicated. I have talked with the state, and we're going to be asking the court to impose this sentence on August 17th, 2023 at 9 o'clock in the morning. And I have explained to Mr. Moore and included on the plea agreement that a failure to appear that day or if Mr. Moore is arrested on new charges prior to that date, this will become an open plea to the court with a maximum potential punishment of 40 years, 60 days in the Department of Corrections.
So it's August 17th at what time?
9 o'clock.
Now, yes, sir, please. Mr. Moore, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Okay, I believe you stated before, Mr. Kleins, that it's 3-year mandatory minimum?
On count 1 in the 1830 case.
Okay. So, any objection to me when I announce the sentence? I would announce it as 3-year mandatory minimum rather than 36 months.
However the court wants to announce it.
No objection, Your Honor.
Mr. Moore, I just wanted you to hear that.
Yeah.
Probably doesn't mean any difference, but there may be some difference. I don't want to violate the statute and say it was 36 months and not 3 years for the mandatory minimum. So that's the only question. Mr. Moore, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I graduated.
From high school?
Well, I got a GED.
Okay, good. I know that's self-motivated.
Yes.
Congratulations. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yeah.
And I know that's a hard one. That's the toughest one to say that. Knowing everything you know, not saying are you happy with it, is it the best decision for you at this point?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No.
Has anyone promised you anything other than what is in the written plea agreement?
No, sir.
The other side of that, did Mr. Kleins or anyone else tell you, Mr. Moore, if you do not enter the plea today, you shall be sentenced to 15 years in prison or any other definite sentence?
No, sir.
Mr. Moore, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. I find that there is a factual basis for entering the plea. The sentencing, well, he's going to be sentenced today and then he reports then?
No, I would ask the court to hold off imposing the sentence. I don't think the court could impose the sentence and let him back out.
I agree, on the DOC.
Correct.
So, Mr. Moore, I'll see you back here August 17th at 9 o'clock, and that's when I'll impose this sentence.
Yes, sir.
Thank you, sir.
Thank you. Sorry, Your Honor, we're just trying to get, last week, so this is El Shabazz Neal. He's got a VOP in 22 CF 3042, and he's got a new law violation in 23 CF 1337. Last week, in the VOP case, I had filed a written denial of the violation. I was just asking Mr. Gomez if he had filed the information in 23 CF 1337. I did not see it yesterday.
There has not been information filed.
If if we can just leave Mr. El-Shabazz Neal's case in 23 CF 1337, if we could put both of these cases together and put it on the first arraignment date in August. We are trying to work toward a resolution here, and so I was just telling Mr. Neal, it's actually better if they haven't charged you yet, because I'll get you an earlier court date.
So the first arraignment date is August 17th. And that's at 1:30. So we're going to have both of the cases August 17th at 1:30.
That'd be great, Your Honor. And we will, of course, if we get any sort of resolution, say before August 14th, we'll advance it on the docket as soon as we get something put together.
So Mr. Neal, I'll see you no later than that, but I may see you before. Thank you, sir.
I'll let you know soon.
Actually, Matthew Jones.
Did you understand what you read? This is exactly what we talked about. Judge, Mr. Jones is with me in 21 CF 1620 and a violation of probation in 21 CF 1324. We have reached an agreement. Mr. Jones has executed an agreement that we talked through yesterday at the jail. The agreement calls for a plea as charged in 21 CF 620. He will be adjudicated guilty, placed on 2 years of state probation. Restitution is going to be ordered in the amount of $779.33, and that is to be paid at $100 per month. A standard court cost of $515 and a $150 cost of defense. In 21 CF 1324, the violation of probation, Mr. Jones is going to be admitting the violation of probation. He will be adjudicated guilty. His probation will be revoked and terminated in that case number with the VOP fee and the cost of defense. So total court costs are going to be $515, $100 VOP fee, and total $250 cost of defense.
And it's an adjudication of guilt in 21 CF 1620.
Yes, sir. And Madam Clerk, the restitution is going to be ordered in 1620. And I'm going to butcher the name, and I apologize. Is it Balula Baptist Church? Beulah.
Right.
Yeah, and the court's going to ask me how long have I lived here. That's BEULAH Baptist Church, and that's at 109 McGriff Street Northeast, Fort Walton Beach, Florida 32548. May I approach the plea agreement?
Yes, sir. Mr. Jones, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand up. Mr. Jones, did you read the plea agreement?
I did.
Do you understand it?
I did.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Mr. Jones, I do accept your plea. You're adjudicated guilty in both cases. Your supervision is revoked and terminated in the VOP case. You'll need to pay the $100 cost of prosecution, $100 public defender's fee. In the new case, you're adjudicated guilty, sentenced to 7 years probation. No, 2 years probation. You'll need to pay the restitution in the amount of $779.33.
Okay.
At a minimum of $100 per month. You need to pay the court cost, $150 public defender's fee, and the $40 per month cost of supervision. As far as the costs in the VOP case, do you want those to roll into the other case where you can pay them then, or do you just want them to go to court?
Yes, Your Honor, if we could include that in the new period of probation, I believe that would be the most efficient thing to do.
Okay, yes, sir. Thank you, Mr. Jones.
Thank you, Mr. Jones.
Oh, you are.
Next will be Brett Phillips.
And Judge, Mr. Jones is on disability. We would ask the court to consider waiving the cost of supervision.
Mr. Jones, how much money do you make per month?
It's usually around $970, sir.
I do waive the cost of supervision. Thank you, sir.
Mr. Phillips.
The written parts of those, it's no contact with minors, it's a no unsupervised contact, and just making sure they put the case on the offender probation, then that's probably by definition. So because there's those additions to the plea agreement, we would need to sign, or just initialed by those. It doesn't change any of the terms. Judge, there were two written parts written into the agreement after we reviewed it. I was just having Mr. Phillips initial those. Mr. Phillips has signed the written plea agreement, and we have an agreement with the state. The plea and sentencing agreement calls for a plea as charged. He will be adjudicated guilty. He will be designated as a sexual offender. And we do need to make sure that we structure this in the right way, because counts 1, 2, 3, and 4 are each third-degree felonies. So the sentence, if I announce it in total and then we talk about the breakdown, would be a 60-month Department of Corrections sentence with credit for all time served, and that is to be followed by a total of 8 years of probation. I believe the most efficient way to break that up would be a 60-month Department of Corrections sentence in count 1 with credit for all time served, to be placed on 60 months of probation in count 2, followed by a consecutive remainder of the probation in 3 and 4. And 3 and 4 being concurrent. I'll defer to the state if they seek any type of breakdown past that.
That's acceptable.
So that would effectively be 5, 5, and 3 concurrent.
Yes, sir.
The sex offender probation would include conditions of sex offender counseling, forfeiture of any seized devices, GPS monitoring set at a minimum standard rate, no internet-capable devices, with exceptions for work, school, or any other exceptions allowed by probation. Mr. Phillips would be allowed to have a basic cellular phone, no contact with minors.
So it's no contact with minors, not unsupervised?
Correct.
That's correct, Judge.
Correct.
After he does his risk assessment, et cetera, he can petition the court based on that risk assessment.
10 p.m. to 6 a.m. curfew, no contact with the victim. $667 in court costs, $150 cost of defense. There was some discussion about entering this plea and setting this off for imposition of sentence. We would be able to move forward and impose sentence today. There is a victim impact statement that was provided by email that the court would have the benefit of, that we would ask the court review and read this victim impact statement prior to the acceptance of the plea and the imposition of sentence.
Yes, sir. Thank you.
And, Your Honor, that would be from the victim's father, and we would ask that it be under the confidential portion of the filing, as it does include the victim's full name.
Okay.
We would agree.
I believe since it was put on the record, I don't.
Thank you.
And also just to clarify that no internet and then the internet capable devices with exceptions for work, school, or any other exception allowed by probation, that modification would have to come through probation before he's allowed to do any of those things.
Correct.
Please.
The last piece of the puzzle doesn't relate to this, but Mr. Phillips does have a pending felony violation of probation in Santa Rosa County. It's his desire to state on the record that he doesn't want to get lost in the shuffle and go to DOC and not handle that. I'm reaching out to my counterparts over in Santa Rosa to try to procure an order to transport, or if this court won't sought to transport, typically a Santa Rosa judge does that.
Yeah, I don't think one judge can force somebody into another county. I think they have to request it.
And that's typically the case, but I wanted to make record that Mr. Phillips is available and wants to be in a position to handle his felony violation of probation so he doesn't get to DOC with that hanging over his head. We're going to make every effort to try to make that happen.
Thank you, sir.
May I approach?
Please. Mr. Phillips, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. Mr. Phillips, are you currently under the influence of any drugs, alcohol, or medication? Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time? You need to wait for me to finish my question, okay? So the answer to that last question was no?
No, sir.
How far did you go in school?
I have a GED.
Good. I know that's self-motivated. Congratulations. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir, I did.
Mr. Phillips, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
I understand.
And do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what's in the plea agreement? The other side of that, has Mr. McKinney or anyone else told you if you fail to enter the plea today, that you shall be sentenced to 10 years in prison or any other definite sentence?
No, sir.
So let me read this letter or the email. Mr. Phillips, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're designated as a sexual offender. You're sentenced to 60 months. With the Department of Corrections, with credit for all time served. That's in count 1. You're sentenced to 60 months probation in count 2, 3 years probation in counts 3 and 4. The probation in count 2 is, in 3 and 4 is consecutive to the 60 months, so it's a total of, it's only 2 years, no, it's 8 years, so it's a total of 8 years. Gotcha. You will need to undergo sex offender counseling. Subject devices are forfeited. You'll need to wear a GPS monitor. You'll have no internet capable devices, with the exception, after probation approves it, any devices for work, school, or any other exceptions that probation approves. You can have a basic cell phone. You'll have no contact with any minors. You'll be on probation, or have a curfew from 10 p.m. to 6 a.m. and have no contact with the victim.
And for the record, Judge, the victim's initials are ASK and her DOB is 7/2/2008.
Thank you. Mr. Phillips, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir.
Please don't forget about this.
Will not.
Mr. McKinney, did you include a score sheet?
I did.
Okay.
Judge, the score sheet was provided with what I handed out there, is that correct?
You're right.
No objections to the score sheet as provided.
Thank you, sir.
Mr. Rice. This is Michael Rice. Mr. Rice is before the court in two cases, 23 CF.
Hold on one second. Yes, sir. Mr. McKinney.
Judge, Mr. Rice is before the court in 23 CF 580 and 23 CF 582. We'd set it over today. It's not on the trial docket, but in an effort to resolve the matter. Given that Mr. Rice is going to Walton County from here, and he's already finished the sentence in Santa Rosa. So we are working towards a lesser included offense and working towards a probation agreement for Mr. Rice. I think it's fair to say that on the record. We don't have those terms nailed down exactly today to enter the plea. So we want to request a continuance until the next pretrial court date, understanding that I don't want to lose the traction that we have, and I want to add this back on as soon as we have an agreement.
So, Mr. Rice, I'll see you no later than September 11th. But, Mr. McKinney, we've got 2 criminal jury trial weeks next week and then 2 weeks after that. You can schedule it up for 8:30 one of those mornings, hopefully when we're not picking the jury.
Yes, sir.
So hopefully I'll see you soon.
Okay.
Thank you,
Appreciate
sir.
y'all.
As soon as I get an answer, I can talk to you. Yes, sir. Yes, sir.
Oh, Mr. Swain.
Mr. Swain is before the court today in 22 CF 1589.
And also 2207.
That's the violation of probation case, I believe.
Yes, sir.
And I've been provided, I don't know if Madam Clerk has the amended information that shows the 4-count amended information. Wanted to make sure that we have acknowledged that on the record. I've been provided a 4-count information. I'm going to waive its formal reading in a plea of not guilty. In that it changes count 3 from trafficking of fentanyl to a higher level, 28 grams or more. That higher level does include a 25-year minimum mandatory sentence. I've also been provided a notice that the state is seeking HFO sentencing at sentencing, and so I would acknowledge receipt of that notice of intent. This is on the trial docket, and I would defer to the state whether or not we're in a position to move forward or not. I know that Mr. Swain wishes for me to not object to a continuance or to request a continuance.
Yes, ma'am.
Judge, we're in a position at this point that it seems most appropriate to continue the case from today. I don't think that we're in a position to go to trial today. We were working towards a resolution of the 7-year minimum mandatory And Mr. Swain represented to the court on Monday that he was not inclined to do that. So that's why the state has refiled, and with adding the notice of intent to seek habitual felony offender. With all the moving pieces that we have going, it doesn't seem that this is ready to go for next week.
And it can't be ready for August 7th?
Timing-wise, no, Judge. I can't do the beginning of that week, and I know we've already scheduled for the end of that week as well.
Yes, ma'am. Okay. So, Mr. Swain, I understand you don't agree to that. But I've got to be fair to the state the same way I have to you seeking continuances. So I do continue at one cycle. I'll see you back here on September 11th. And we'll be looking at going to trial that cycle. Okay? Thank you, sir.
Taylor?
This is Mr. Gordon Taylor. Mr. Gordon Taylor is here in 22 CF 54. There's two violations of probation that are tracking along pending sentencing. That's 21 CF 3268 and 21 CF 1243. I believe that the state's intent is to file an amended information, changing this to a 3-count information. And there's been some discussions related to that about potential resolutions. I want this to remain on the trial docket, but I'd like, since there's a 2:30 docket today, if we can see Mr. Taylor at 2:30 today to see, once we have the amended information from the state, how that changes the score sheet, to see if that changes the position of the parties.
Yes, ma'am.
Judge, just for the record, at this point, I do have the information. I just need it notarized. It's not changing the charges themselves. It's just condensing what the trial would be if and when we go to trial. The anticipation is the end of next week. We would be trying the case probably Thursday, Friday of next week. I have provided Ms. McKinney an updated score sheet showing what the state is filing as far as the condensing of those charges. It would be 2 felonies and then 1 misdemeanor would be the anticipation for trial.
Okay. So, Mr. Taylor, I'll see you this afternoon after 2:30, okay? Okay. Thank you, sir.
Thank you.
It is. It's different from what we talked about yesterday based on me handing, they went and did their homework on the score sheet. The score sheet comes to the minimum guideline sentence of 24.07. Yes, sir. It is unfortunate. Yeah, do you have any questions? Yes, I guess. And Judge, I was reviewing the score sheet that was provided us today in 23 CF 933 and 22 CF 2555. And we discussed this yesterday at the county jail, but I did, because there's a change in the number on the score sheet, I wanted to make sure that Mr. Tennis was aware of that change because it affects his sentence. The minimum guidelines would be 24.07 months Department of Corrections, and the agreement calls for an adjudication of guilt as charged for a concurrent sentence that is also concurrent with a current DO sentence in 20 CF 1930 and 20 CF 1940, which is, he's already sentenced to the Department of Corrections in a separate sentence. There would be $1,140 in court costs and $150 cost of defense.
So, what is the sentence?
It would be 24.07 months Department of Corrections concurrent between the two case numbers before Your Honor and concurrent with the other case numbers that I announced.
Understand. You just said there was a minimum of that.
No,
You never said
yeah,
what the sentence.
that is the minimum guidelines, and that is the sentence. So Mr. Tennis has reviewed a plea agreement. He would need to execute that agreement if that's acceptable. Today is 7/20, 23rd. You're fine.
Mr. Tennis, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, sir. Tennis, approximately how much longer do you have to serve in prison on the 20 CF 1930 and 20 CF 1940 case?
I believe it's gonna work out around, I believe we figured out about 18 months, 19 months, yeah.
Okay, thank you. Just curious how long my colloquy had to be with you. Mr. Tennis, did you read the plea agreement?
I did.
Do you understand?
I did.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Mr. Tennis, I do accept your plea. You're adjudicated guilty. You're sentenced to 24.07 months with the Department of Corrections with credit for all time served, and that's to run concurrently with each case and each count. And that's also concurrent with 20 CF 1930 and 20 CF 1940. You will need to pay the $150, I'll get it straight, a total of $250 public defender's fee and all monetary assessments mandated by statute or county ordinance are imposed. That's the court costs on the two new cases.
How long do I have to pay that for?
Well,
Typically, it's in the collections if we want to DOC. But you're asking
right,
for
since you've got months left in the Department of Corrections, can he try to schedule up a payment plan with the clerk after he gets out?
After he gets out, yes, but if it's already gone to collections, I believe that's going to be his problem.
Mr. Tennis, if you fail to pay all outstanding financials within 6 months after you're released, then they'll go to a civil lien or judgment.
All right. Get out of payment plan as soon as you get out.
Mr. Dennis, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do, sir.
Thank you, sir.
Thank you very much.
Misdemeanors, time, sir. Yes, ma'am.
Thank you very much.
This is Mr. Peyton Troutman before the court. Mr. Troutman is here in 23 CF 623 and 21 CF 2285. Judge, Mr. Troutman is here in the 23 CF 623, 21 CF 2285. The 2285 is a felony violation of probation. The agreement that's been reached in both of these cases is that in 2285, the state is going to keep the withhold of adjudication on the agreement here, reinstate the complete original requirements, and modify to include the Phoenix House program. He is approved for that program. That is going to be bars to bed. There's going to be a $100 BOP fee, $150 cost of defense. In the new 23 CF 623 is also going to be a withhold of adjudication, 2 years of probation concurrent with his current supervision, that's $615 for cost, an additional $100 cost of defense. That's concurrent terms of probation, and it also includes the Phoenix House bars to bed. We would ask the court to waive the cost of supervision while he is in inpatient. and his dad is present in the courtroom in support. May I approach?
Yes, sir, please. Mr. Troutman, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. Mr. Troutman, did you read the plea agreement?
Yes, sir, I do.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Troutman, I do accept your plea. Adjudication is withheld. Your current supervision in 21 CF 2285 is reinstated with the original terms and conditions. However, it's modified so that you'll need to enter the Phoenix house. I'm not saying successfully complete because I don't know if you have enough time for that, but you'll certainly have to do that in the other sentence. You'll need to pay the $100 cost of prosecution, $150 public defender's fee, and 23 CF 623, adjudications withheld. You're sentenced to 2 years probation. That's concurrent with probation in the 21 case. You also have to enter and successfully complete the Phoenix House program. Both of those are bars to bed. Bars to bed. You'll need to pay the $100 cost of prosecution. That's a new case, right? So you'll have to pay the court cost in that and the $100 public defender's fee. The court does waive the cost of supervision while you're in Phoenix House. Mr. Troutman, your dad being here all day for you, the withhold of adjudication says a lot. A lot of people want you to succeed. I wish you the best, sir.
Thank you.
Yes, sir.
Judge, for the record, this is a negotiated downward departure as well.
Mr. Troutman, on top of the withhold, that also shows there's a lot of hope for you. I mean, the system, everybody believes there is that. I know your dad believes that. Thank you, sir.
Thank you. Thank you.
Do you have a score sheet for Mr. Troutman?
We'll supply it.
So this is Mr. Broderick Buster, first day before the court in 22 CF 2782. Judge, Mr. Weathersby is on the docket today, and we are not on the trial docket next week. I don't believe that we were as close as we thought we were based on the discussions with the state. I believe the state's offer with Mr. Weathersby is 30 months Department of Corrections, but with a reduction in the sentence from a carjacking down to a GTA. That's something that I've discussed with Mr. Weathersby at the jail. I'm going to request a continuance today, given that we're not on the trial docket, to see if we can continue to work on this case, and if it's not resolved by next cycle, then we would be setting it for trial at that time.
Yes, ma'am.
Judge, I think that's an accurate reflection of where we are with the case at this point.
So, Mr. Weathersby, I'll see you no later than September 11th, and we'll be looking at going to trial in September.
But I would like the opportunity to bring this back on to an earlier docket if we continue to keep hands on it and reach an agreement that we can come to an earlier resolution.
Mr. Weathersby, if the state offers you something that you want to accept before September 11th, Mr. McKinney can put it on the docket, and I'll see you. Is that right?
No, we already did run. It's going to be Newsom and then Pearson review paperwork with the attorney. I'm running the bill, be ready to do it. And then the state's going to be reasonable here as well.
Good. Yes, sir. Absolutely. Whoever you've got ready, please.
Newsom. Newsom's in there. Next will be Stephen Newsom.
Thank you.
Your Honor, this is Stephen Newsom in 23 CF 1331. He's on the 130 arraignment docket.
Yes, sir. Good morning.
Good morning, Your Honor.
Your Honor, we do have recount information for Mr. Newsom.
We will waive the formal reading, enter a not guilty plea. I will ask that this remain on the September 11th docket. However, I have already talked to Mr. Gomez and Mr. Newsom, and we are trying to arrange some kind of an early disposition here. So the second we have something agreed upon, we'll get Mr. Newsom back in front of the court.
Your Honor, if I may?
Yes, sir.
There is a charge on my record that I've never been arrested for, nor have I ever been convicted of. And this is the 5th time. I mentioned something the last time I was in court back in March that it was the 4th time. And this is borderline incompetence, Your Honor. I'm not complaining. I understand that the State's Attorney's Office is swamped.
Mr. Klein, you're aware of that?
Fully aware of that. I actually handled the case last time, and that's what I had informed Mr. Gomez today was, hey, when you're putting the score sheet together, there's a burglary on that score sheet that is going to be improper. I've looked into that. It was pled to something totally different last time. So Mr. Gomez is already aware of that. So I don't have a score sheet yet, so I don't even know if it's going to be on there. But
Good, Mr. Newsom, I'm glad you raised it.
Thank you,
I'll see you no later than September 11th, but hopefully I'll see you before then.
Thank you, Your Honor.
Thank you, sir.
that's for you. That's as soon as I know something.
Thank you.
We'll pass over Mr. Pearson briefly and do Mr. Williams.
Okay.
Disregard for Pearson's done and try to find Mr. Pearson, but the public defender is on the way back from.
Your Honor, while we're waiting, there's 2 other people that were on the trial docket this morning.
Yes, sir.
We have Crystal Owen in 22 CF 250. I did speak with Ms. Owen yesterday, and Mr. Gomez got me the payment information yesterday. I think the appropriate thing to do would be to remove Ms. Owen from the trial docket. That we were trying to get that paying dismiss contact information. Put Ms. Owen's case for status on August 14th. But I talked to her yesterday, and we're going to get that payment made probably in the next week or 2.
Yes, sir.
I agree with that, Your Honor.
Okay, so 22 CF 250 is, so we're just going to continue it until August?
I would just ask, because I know the 11th is going to be a monster docket, put it on the August 14th for status, but I expect this to be dismissed before then.
So we'll continue the cycle and then just put it on the first. Good.
And then I'll step aside since
Mr. Pearson. Pearson is involved by unrepresented women.
Hello, Mr. Pearson.
Hello.
How are you doing?
Okay, how are you, sir?
I'm doing well, thank you. What are the blue things in your ear?
Oh. They're earplugs.
Oh, okay. Good. I didn't know whether that helped you here or not.
No, it didn't.
Okay, good. Yes, sir.
Yes, Your Honor, Thomas Scott for the record. This will be a change of plea of no contest as charged. Your Honor, this will be credit for time served. Court costs of $515. And then there's a $150 defense cost. If I just may have a moment for my client to sign, Your Honor.
Yes, sir.
Right there.
Here?
Yes, sir.
I'm on the CBA ground, so I have to go.
Take your time.
Your Honor, I just want to make sure I clarify the court cost for the record. I believe it's supposed to be $515 in court costs with a $100 cost of prosecution for a total of $615, correct?
The 515 includes the 100 prosecution.
I'm just going to fix the date right here. Your Honor, may I approach with the police warrant?
Yes, sir. Thank you. Thank you, sir. Mr. Pearson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So, guys.
Thank you, sir. You can put your hand down. Mr. Pearson, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you sign it?
Yes.
Mr. Pearson, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You need to pay the court costs, $150 public defender's fee. How long will it take you to pay about $700?
Is 6 months okay?
Yes, sir. If you fail to pay it within 6 months, then it will go to a civil lien or judgment. Okay.
Yeah, I'll pay it.
Good. Thank you, sir.
Thank you.
Thank you, Judge.
Thank you, Mr. Pike.
Should I hang on to this?
Yes, you just go towards that.
Should be Williams next. Williams? I heard his name. Oh.
Well, Mr. Williams.
How you doing?
Good. Is Mr. Williams on 130?
Yes, Your Honor.
Yes, sir. And it's case number 23 CF 1332. Mr. Williams, do you wish to represent yourself, or do you want me to appoint a public defender if you qualify financially? Okay, how much money do you make per month? Okay, I do appoint a public defender to represent you.
Yes,
And that is approaching on your right.
My contact information. Judge, we would acknowledge the receipt of a 4-count information, waive its formal reading. Inward plea of not guilty is scheduled for September 11th at 9 a.m. For pretrial. I'll open the file, speak to the state, see if there's any offers that I can convey to Mr. Williams, and go meet with him at the jail.
Let's stop 1 second. Is there an offer from the state, Mr. Williams?
Mr. Williams scores 19 months in prison on this.
Okay. Thank you, Mr. Williams. So I'm going to see you on September 11th.
Yes, Your Honor.
Good, I'll see you then, sir. Who's the young lady in the back?
We have one more case on the trial docket, Elizabeth McIntosh.
22 CF 2217. I talked with Mr. Gomez this morning. I believe the state's going to request a continuance. We would be not objected to it.
I didn't have this case listed as one was can be set on this to try to get a resolution, because this is one of those instances where the victim made some representations in depositions, and I am just trying to make sure that we comply with Marcy's law before we dismiss any case. And so I just want to speak with him personally. I think if we just continue this to the September 11th docket, this is going to fall off the docket, because based on those representations and depositions, I just kind of want to double check and make sure that that's what the victim is okay with.
Okay, it's continued until September 11th.
Thank you.
Anybody else in the back? Gallery looks empty. We're in recess until 1:30.